Hi everyone. Thank you for joining us today for our webinar, Evolving Chemical Regulations, TSCA Reform, and Consequences for Global Business. Today we will cover various aspects of the TSCA Reform Bill that was recently signed into law and solutions for managing evolving regulations. My name is Jessica Chen. I work with the Business Development Department at Source Intelligence, and I will be moderating today's broadcast. Before we get started today, let's review several housekeeping items first. First of all PowerPoint slides and a recording of this webinar will be emailed to you after today's presentation. They will also be available on our website, sourceintelligence.com/webinar library. If you have any questions during the presentation, feel free to type them in to the GoToWebinar control panel. We'll send out answers to any questions we can't get to during our Q&A. You can also email questions directly to education@sourceintelligence.com. We will be hearing from several experts today about TSCA reform, its consequences for business, and how to manage evolving chemical regulations as a whole. Today's webinar will be focused on providing a broad overview of the new law and the evolving chemical regulatory landscape. Zephan Specht is Source Intelligence's regulatory expert. He has extensive experience in chemical research and chemical regulations. Zephan holds a doctorate and master's in chemistry. Thomas Berger and Eric Goding are both partners with Keller & Heckman, a leading law firm that has counseled clients on compliance and policy issues throughout the recent TSCA reform efforts. Keller & Heckman's staff includes both scientists and lawyers, providing both technical and legal expertise to their clients. We are very excited to have Thomas and Eric share their legal expertise on TSCA reform today. During our webinar, Thomas will first review the differences between the old and new TSCA, consequences of the new TSCA for businesses, and implications for exporters. After, Eric will tackle the complex topic of federal preemption. Zephan will close by examining the role of data in managing compliance and will provide recommendations for how to manage the overwhelming demands of evolving regulations. As a reminder, you may ask any questions you'd like during the webinar. Simply post them in the chat box on the bottom section of the GoToMeeting. Before we delve into TSCA, let's first take a broader look at regulatory trends. Chemical regulations worldwide are constantly undergoing changing requirements. As examples, we can look at some of the most discussed chemical regulations out there: European REACH and RoHS, and California Prop 65. The list of regulated chemicals is continuously growing. What companies have to do to comply changes as well. Substances are added to REACH's list of candidate substances, which is known as the SVHC list, every 6 months, and likewise the list of banned substances under REACH changes over time. Definitions of scope and what products or substances are exempt under certain applications are also subject to constant change. Exemptions under RoHS, for example, are assigned sunset or expiration dates, but these can be challenged by industry and revised. Applications for new exemptions can be submitted as well, making it especially challenging for companies to keep track of new developments and how their products will be impacted. Different product categories also have different timelines for compliance. Medical devices were first required to comply with RoHS by July 2014, whereas in vitro diagnostic devices needed to comply by July of 2016. The regulations themselves can be amended and reformed as well. Directive 2015/863 added 4 additional phthalates to be restricted under RoHS. It's important to recognize that TSCA is part of the larger machine of chemical regulations that have shifting requirements, and the reform bill recently signed into law has put it into the limelight. The TSCA Modernization Act, also known as the Frank R. Lautenberg Chemical Safety Act for the 21st century, that was just signed into law on June 22nd, will completely change EPA's ability to regulate toxic substances and redirect America's federal approach to chemical management and restriction. Tom will provide a broad overview of these changes and what it means for businesses. He has extensive experience assisting clients in bringing new products to market and has broad experience in chemical and product liability management. The core focus of his practice is on the regulation and approval of new and existing chemicals under TSCA. He's told me that he has lots to review, so I'm sure he's eager to dive straight in.
I'm going to cover it at a fairly high level, so hang on. Here we go. So about 2 weeks or so ago, President Obama signed long-awaited TSCA reform legislation. As you may know, TSCA was enacted way back in 1976, some 40 years ago, and hadn't been significantly amended since 2 weeks ago. So now we have new TSCA, and that's what we're going to talk about today. The HR 2576, the bill that amended TSCA, basically amended the sections you see right here on this slide. Some amendments were made to some other sections. We don't have time to cover those today, but as we move through these sections, I think we need to note what has not changed. So let's go through these pretty quickly here, though. First of all, TSCA's got now has 17 definitions, used to have 14, and the pre-existing definitions were not modified. And we'll talk about what that means in a little bit. Second, the basic Section 4 testing authority and the data compensation provisions were unmodified by TSCA reform. Third, the basic framework for TSCA Section 5 pre-manufacture notices and significant new use rules, or SNURs, also was not changed. Certainly there were some modifications to the procedures and timelines, but the basic framework did not change, and we still do not have a base set testing requirement, forgive me, for new chemicals. Once again, we do not have a base set testing requirement for new chemicals, as some feared might happen. Fourth, the TSCA inventory has been retained. Those of you familiar with EU REACH in Europe or earlier versions of TSCA reform may note that in both those cases, basically the inventory would be thrown out and you start again with everything as a new chemical. That did not happen here. The chemical data reporting requirement, you'll be sad to hear, is still on for reporting in 2016. Sections 8C Charlie, D, and E Edward are the same as they were before reform. And as we'll discuss, export notification and export only provisions remain, as do the Section 13 import cert requirement, basically in its pre-existing form. Okay, let's move our way through the sections of TSCA that I showed on the earlier slide. And let's focus on the three new definitions that we have, and particularly the first and the third one. And the first one, conditions of use, and I won't read you this definition, really is critical to amended TSCA. As we'll discuss, when EPA reviews a Section 5 notice, they have to review it under the conditions of use as shown in this definition, and that really does change how TSCA works in terms of notifying new chemicals. The third definition, potentially exposed or susceptible subpopulation. EPA, as we'll discuss, also has to take that into account when they review notices, and it just takes into account the fact that some groups have an increased risk of adverse effects. And we don't really need to cover the definition of guidance today. Okay, Section 4. Those of you familiar with TSCA know that Section 4 of TSCA allows EPA to require testing of chemicals in which EPA becomes interested. And it's a pretty high standard for EPA to require testing, and it's done through a full-blown administrative rulemaking process. So it takes a lot of manpower to issue a Section 4 test rule, and that's why we've only seen, I guess, a couple hundred test rules in 40 years of TSCA. So now, under new TSCA, EPA can require testing not only by rule, but by order or consent agreement, and can require exposure information as well. So that gives EPA a lot more flexibility and makes it easier for EPA to issue test rules. And basically, EPA now also can issue test rules to basically implement new TSCA. You can see all the sections of TSCA here in the third bullet. And some other things were expanded. EPA also generally has to tier testing and has to reduce vertebrate testing to the extent practicable. Also, the Interagency Testing Committee established under Section 4A is going to be expanded to include 10 members as shown on this slide. Okay, those of you familiar with TSCA are probably very familiar with the PMN and SNUR process, right? And that is if you manufacture or import a new chemical substance, you need to submit a pre-manufacture notice at least 90 days before commencing manufacture or import. Similarly, if you have a substance that's subject to a significant new use rule, you have to submit a SNUN at least 90 days before undertaking a new significant new activity. And that has not changed, that basic framework. What has changed, and this is the second bullet, is now when EPA reviews one of these notices, it has to make an affirmative determination under Section 5A3 for the chemical. And that determination needs to be based on the conditions of use. As we discussed, third bullet, sub-bullet there, it has to include the risk to susceptible populations. And going back to the second bullet, EPA is prohibited from considering cost or non-risk factors when it reviews a PMN or a SNUN. And that is very different from current TSCA. Finally, if some workplace issues are basically at issue, EPA, to the extent practicable, can defer it over to OSHA, but we're not certain you're going to see that happen too frequently, quite honestly. Next slide. So as I mentioned, when EPA reviews one of these notices, it has to make an A, B, or C determination, right? And they go from bad to good. Let's start with A. A is bad. That means the substance presents an unreasonable risk under the conditions of use. That's not a good finding, as we'll discuss on the next slide. The third finding is the opposite, and this is where you submit a PMN, and EPA essentially drops the PMN and approves the substance. In the middle really is where things have changed, the B determination. And you can see the green or that's underlined here on this slide. That used to be an and that was changed to or in the statute. And basically what that does is allow EPA to regulate a chemical simply because it lacks sufficient information on the substance. So in short, we think this will make it more difficult for chemicals to successfully make it through the PMN process. So here's what EPA has to do if it makes one of these findings. If it makes the A finding, again, that's the presents an unreasonable risk finding, EPA has to use Section 5F and may issue an order under Section 5F. The B finding, which again we believe you'll see when there's insufficient information, EPA has to use Section 5E Edward and has to issue a Section 5E order, many of you are familiar with. And finally, if EPA has no concerns essentially under C, then as under old TSCA, companies can commence non-exempt manufacture or import. And in fact, you can do that even before the review period ends. And that's very different from old TSCA, where you had to wait 90 days, even if EPA had concluded that no unreasonable risk was posed many days before that time. There's much discussion about articles under TSCA, and articles are items that are formed to a definite size or shape and basically don't have any chemistry going on. And the statute makes it very clear that EPA can require a significant new use notice for chemicals and articles if they make an affirmative finding in a rule. And you may recall that EPA did this in 2013 for certain perfluorinated chemicals in carpets. I think I've got 3 or 4 slides here on Section 6. We'll cover these pretty quickly, even though this was a significant part of TSCA reform, if you will. So the first 2 bullets are pretty important. First of all, the basic standard for regulating an existing chemical has not changed. The standard is no unreasonable risk. The second bullet is very important. Many of you may recall that basically in this corrosion-proof fittings court decision in 1991, the court basically eviscerated Section 6, and EPA hasn't tried to use it since because it couldn't meet the least burdensome restriction that the court imposed upon the agency. And so that really limited EPA's ability to regulate existing chemicals under TSCA. So that has gone, and so we now believe EPA is going to be using Section 6 a lot more than it has. So the new Section 6 does a number of things, and you can think about it as taking the 85,000 or so chemicals on the TSCA inventory and prioritizing them and assessing them and designating them as low or high priority, and then managing them under Section 6A rules. And again, this is just by way of summary. All sorts of rulemakings are going to have to occur to basically allow EPA to implement Section 6. And this is just a very, very quick overview of some of these rules. But within a year from now, EPA has to promulgate a rule that basically establishes this screening process for prioritizing chemicals, as well as a rule establishing how EPA is going to evaluate the risks of chemicals. So we anticipate very, very large rulemakings with lots of public comment on these two issues. Here's a slide that EPA put out in last week's EPA webinar on TSCA implementation. It's way too much detail for today, but you can see all the steps that go in and the public participation in the Section 6 process. So if a chemical is put through the Section 6 process and EPA finds that there is an unreasonable risk, EPA can basically take risk management measures. And that basically means EPA has to propose a Section 6A rule within a year and finalize it within 2 years of its final risk evaluation. And there's certain extensions that can come into play here. And I won't read the rest of the slides, but there are some exemptions from some critical things. And articles can be regulated to the extent necessary to address specific risks. So once again, if EPA evaluates a chemical and finds that there is an unreasonable risk, EPA will use its Section 6 authority to regulate the chemical. Moving on to Section 8, as I mentioned, no changes to Section 8C, D, and E, but a fair amount of changes to Section 8A and B. As I mentioned at the outset here, those of you who are familiar with TSCA may be working on, and I hope you are, the 2016 chemical data reporting requirement. Reports are due to EPA by September 30th of this year, and that deadline remains. So unfortunately, TSCA form did not do away with CDR, and if you haven't been working on that, you may want to start now, because September 30 will be here before you know it. Second bullet is pretty specific, and we won't cover that today. Okay, some of this is important. Nomenclature is very, very critical to TSCA, and the statute requires EPA to maintain the use of what we call Class 2 nomenclature, and this is where EPA treats certain complex combinations as if they were individual substances. EPA is also required to maintain the use of Soap and Detergent Agency, or SCA nomenclature. That's critical, and that provides some flexibility in certain areas of chemistry. The third bullet, I think, is intended to address ceramics and similar things that became an issue in the last 10 years or so. And the big bullet down at the bottom, I still am not sure what this is intended to get at, except to recognize that potentially there may be more than one way to name a substance for TSCA purposes. Okay, this is important stuff, and this is going to be kind of short-term stuff. So let's take a look at that first bullet. So let me kind of just read this to you, given its importance. So within a year from now, EPA has to issue a rule that's going to require producers, and by that I mean manufacturers and importers, and also may require processors to notify EPA within 180 days of all the substances that they produced within the 10 years prior to the enactment of this law. So that means the third and fourth quarter of 2017, that's next year, companies are going to have to notify EPA about all the chemicals, basically, that they made or imported and may be processed within the prior 10 years. So this is a big deal. And those substances that get reported by industry become quote-unquote active substances, and those that do not get reported are inactive substances. They remain on the inventory. EPA can't delist inactive substances, and they can't require PMNs to be submitted for inactive substances. And we'll talk about some of these other issues later. So if a substance was not notified under the Section 8B rule, again, it becomes an inactive substance. And if you want to manufacture it or import it or process it, you have to notify EPA in advance. And if you notify it, you have to basically assert confidential business information or CBI claims. And if you do notify it and everything is acceptable to EPA, they will move the substance to the active list, and then the substance will be put through the Section 6 screening process, just like any other active substance. CBI, geez, we could talk for a long time about this, but we don't have time today. But basically, it's been completely rewritten and replaced. Long story short, basically, CBI can be preserved for information that's important to industry, but more information will be made public. And at the last two bullets, there's all sorts of procedures and timelines at issue now, and much more, many more CBI claims will require substantiation. And I've tried to highlight some of the important things, I think, or at least the areas in which CBI is going to come up more frequently on this slide. And basically what you have to do is, if you're going to make a CBI claim, you have to make it at the time you submit the information, and you have to substantiate it for most types of information. And I've just highlighted some of the timelines here. And down at the bottom, for example, substances on the confidential portion of the inventory can be claimed confidential for basically 10-year intervals that are extendable. HR 2576 did amend basically the penalty provisions of TSCA, and the penalties have increased as shown on this slide. And basically what has been done here is TSCA has been made basically more consistent with other federal environmental statutes, such as the Clean Air Act, Safe Drinking Water Act, etc. So that's really all that has happened here. We did not used to have this organizational penalty shown at the bottom of this slide, but now organizations can be fined for criminal violations of TSCA. Just briefly, and I think the takeaway here is that all these additional EPA activities are not going to be wholly funded by industry. Basically, roughly 25% of the cost are going to be paid or borne by industry, and EPA is going to pay the rest. You may know, for example, that the PMN filing fee is only $2,500 US, and that's been that way for many, many years. We certainly anticipate that that's going to go up, and certainly there are fees in place for Section 6 actions as well. A couple kind of miscellaneous provisions, although they certainly are important. And basically implementing TSCA reform, EPA is required to use the best available science and make decisions based on the weight of the scientific evidence. We'll see how that plays out. The second bullet, EPA has got to develop policies and guidance documents and procedures. I think what's notable here is in earlier versions of TSCA reform bills, we saw that EPA had to do this using notice and comment rulemaking, and we don't see that here. So these guidance documents will not go through notice and comment rulemaking, but theoretically are binding on industry. EPA has to establish the Science Advisory Committee to provide consultation on technical and scientific issues within a year. There are specific savings clauses that preserve actions taken by EPA under old TSCA, if you will. So those are still good. For example, if EPA promulgated a SNUR, that SNUR is still good. There have been questions raised about pending actions. For example, what if you filed a PMN 2 months ago and it basically bridged over enactment of TSCA reform? And the answer is EPA, it basically took the position that PMN review periods restarted on June 22nd of 2016. And if EPA basically began a Section 6 action before the 22nd, it can basically proceed under the new Section 6. So what does this all mean for business and industry? As I mentioned, the definitions in Section 3 of TSCA, the existing definitions did not change. Among those definitions was the definition of chemical substance. And that really set forth TSCA's jurisdictional scope, because the term chemical substance was and is defined to exclude things like foods and drugs and cosmetics and medical devices. And because that language was not changed, those types of chemicals have not changed. So TSCA's overall scope is unchanged, and the things that were within TSCA's jurisdiction a month ago still are. What you are going to see are more Section 4 test rules. As I mentioned, current Section 4 normally restricts EPA to proceeding under Section 4 only by issuing a formal Section 4 test rule, but now, since EPA can do it through less formal procedures, we think you're going to see more Section 4 test rules issued under a new TSCA. And when a Section 4 test rule or action is issued, it can trigger legal obligations. For example, can trigger the need to submit a notice of intent to test or request for exemption from testing, and a fairly tight time frame. And as we'll discuss, Section 4 test rules also trigger export notification requirements So we're going to see a lot more of that. And of course, Section 4 test rules are designed to have industry get together and co-sponsor and co-fund toxicity testing, so you'll see more of that. We also believe it's going to be more difficult to get new chemicals through the Section 5 PMN process, right? As I mentioned, EPA no longer can do a cost-benefit analysis, and they're strictly prohibited from doing so. We also talked about the susceptible subpopulations that have to look at that. EPA also has to make an affirmative approval of a chemical. Whereas before, basically, if EPA took no action, the PMN was deemed approved at day 90. As I mentioned, however, we do have this green light provision where if a chemical is approved by EPA, say 45 days into the 90-day review process, you can basically begin manufacture or import on day 45, and you don't have to wait the full 90. So we think that's significant. Needless to say, a big focus of TSCA reform was Section 6 and the amended Section 6. All this prioritization and screening and risk evaluation is going to pull a lot of substances, at least a fair number of substances, through the Section 6 process. So what you're going to see, we think, is the EPA using its Section 6 authority for the first time since 1991 to ban chemicals, at least for certain uses that are of concern to EPA. We also think that given EPA's increased authority, you're going to see companies basically voluntarily phase out chemicals or customers deselecting chemicals that are making their way through this process. And needless to say, when you have rulemakings and activities against classes of chemicals, you often see a fair amount of trade association activity, and we think that will continue. As I mentioned, you're going to have all sorts of rulemakings under Section 6, for example, to set forth these procedures. You're also going to have chemical-specific rulemakings for specific chemicals under Section 6. So all sorts of activities in the rulemaking arena. This may lead to litigation, since there are a number of things now that constitute what we call final agency action, which gives companies the right to bring suit against EPA. I think in the shorter term, as I mentioned, in the third and fourth quarter of next year, for example, we have this inventory reset where you have to notify EPA about the chemicals you manufactured or imported in the previous 10 years. And I guess on one hand, that should be a straightforward exercise. On the other hand, as I mentioned, TSCA is very, very nomenclature driven, and I think it's going to force companies to basically figure out some nomenclatures between now and the end of next year. And in fact, I think companies are going to have to do that before September 30 as they prepare their 2016 CDR forms. We just touched on CBI and the new procedures EPA has, but again, for a company to go back and substantiate confidentiality claims for all chemicals that are on the inventory, and for EPA to police these claims, I think it could be a very, very burdensome activity for both industry and EPA. Exporters, a couple things under Section 12 of TSCA. First, I think it's interesting to note that while certain countries that have laws like TSCA have reduced notification requirements for exported substances, only TSCA, I believe, completely exempts export-only chemicals in most cases from basically the need to be on the inventory and the need to go through new chemical notification. So TSCA's got a very, very broad export-only exemption, and that was retained in H.R. 2576. So I think that's important to note. Second, Section 12B export notification requirements, which require you to notify EPA before you export certain types of regulated chemicals. That requirement continues and is in effect basically unaltered. And as I mentioned, because you can see more Section 6 rules and more Section 4 test rules, Section 12B export notification is going to be triggered more frequently now than it has been in the past. Finally, Section 12C of TSCA, we have this mercury export ban for mercury, basically elemental mercury. Mercury compounds has been added to this export ban for all these forms of mercury I have here. And any mercury compound that EPA adds to this list within 90 days. So that's going to be a fairly short-term rulemaking activity by EPA. So if you export mercury compounds, you may want to keep an eye on and participate in this rulemaking. So I know that was a whirlwind tour of TSCA reform, but that's it in a nutshell. Thank you for listening.
Thanks, Tom. That was really informative. So I see that we're also getting quite a few questions in. Just as a reminder, we are having the Q&A section afterwards, but if we aren't able to get to your question, we will still be following up after with the questions and a list of answers. So now I'll pass the floor to Eric to discuss preemption within the new TSCA. Eric counsels and defends clients in a broad range of areas, including product liability, toxic tort, and environmental law. He has counseled chemical companies on TSCA preemption throughout the entire reform process.
Well, thank you for having us today. I'm going to be talking about preemption, and as many of you probably know, this is or was kind of the third rail during the congressional negotiations on TSCA reform. It was very contentious. A lot was given up by industry on preemption to get kind of the overall reform bill passed, at least when you compare it to the preemption clause that we saw in the first Vitter Lautenberg bill 2 years ago. And so what we've been left with is really a preemption clause that is very narrow in scope. But before I get to that, I'm guessing that some of you are probably very familiar with what preemption is and how it works, but some of you may not. So I wanted to do a quick preemption 101. So what is preemption? Well, it's basically the extent to which federal law trumps state law. And this comes from, as you may recall from your high school government class, the supremacy clause of the U.S. Constitution. And there are basically two kinds of preemption. The first is what we call express preemption, and that is very easy to identify. It's because it's where a federal statute explicitly says we are preempting state or local laws, and this is how we're going to do it. The second kind of preemption is called implied, or sometimes people call it conflict preemption, and this is a little more difficult to spot, and it can be actually pretty complicated. But I'll give you a simple example. I think the easiest way to understand this is at least one version of it, which is what we call impossibility conflict preemption, and that is where it is literally impossible to comply with both the federal statute or law and the state or local law. If you comply with one, you would be violating the other, and I'll give an example of that soon. But you will see as we talk today that we see both types of preemption in the TSCA reform bill. So in talking about preemption, I like to divide the preemption clause in the reform bill, which runs for pages, into three kind of categories or questions. And so the first is what happens to all of the existing state laws that were on the books before President Obama signed the reform bill into law. The second group would be what happens, or the second question would be what happens to all of the new state laws and new local laws that are adopted after the effective date of the reform bill. And then finally, what types of exemptions or state waivers do we have that would allow states to get around and avoid preemption where it would otherwise apply. So my first slide here deals with that first question, and that's existing state laws. And here we have very little preemption, and the main reason is we have this grandfather date in the reform bill. Any action that is taken by a state or a locality prior to April 22nd, 2016 is not subject to preemption. That applies to high and low priority chemicals, and so in essence they just stay on the books. There's also an exemption, an explicit exemption for Prop 65 issues, labeling primarily, so those are exempted. And then just to make sure you understand, low priority chemicals aren't subject to preemption, excuse me, preemption at all. So even when you have that low priority designation, it's not preempted, and that was not the case in the original Vitter-Lautenberg bill a couple years ago, but that was one of the things that industry gave up. Now, there are a couple exceptions here to existing state laws. If EPA has adopted a specific test rule under Section 4, or a significant new use notification under Section 5, that would preempt any similar state or local law on that chemical. So even if they were existing, the way I read the statute, the grandfather clause wouldn't protect those provisions, that they would indeed be preempted. Now, that's a very narrow exception to the no preemption or the grandfather clause, but an exception nonetheless. The other possibility here is conflict preemption. And so the way I read the statute is that even if you have an existing state law, something that would fall under the grandfather date, for example, that ultimately conflicts with an action taken by EPA, I think industry could still argue that conflict preemption applies. There's no explicit provision in this statute that says conflict preemption does not apply. And so an example would be if you had a labeling law, a state labeling law that said you can only use the word danger on your label for a particular chemical, and then EPA comes along later and says, no, you have to use the word warning and no other signal word. And so there you have that impossibility conflict. It's impossible to comply with both at the same time. If you're complying with one, you're violating the other. And I would argue that even if that state law is grandfathered in, that conflict preemption kind of trumps that, and you could argue that you still have preemption in that instance. But that's going to be somewhat rare. And so again, we have very little preemption for existing state laws. Going on to the next slide, now we're dealing with new state laws. What about all those actions that states are going to take in the future after the effective date of the reform bill? And here we have preemption that is a little broader in scope, so that's good news. And we have this unique feature that you don't see in other consumer protection statutes, federal consumer protection statutes, and we call it the preemption pause. And this only applies to high priority chemicals, because remember, low priority chemicals aren't preempted. And it starts, this preemption pause starts when the scope of the risk evaluation is defined. So that is before EPA ever makes a decision on the high priority chemical, whether it's a risk or it's not a risk. And so preemption is kicking in earlier than it would normally under a consumer protection statute. And that preemption pause ends when the risk evaluation is published, in other words, when EPA decides if there's an unreasonable risk or not, or 3.5 years have passed, whichever's quicker, whichever's earlier. That's basically how long EPA has to do the risk evaluation. And so during that period of time, neither EPA nor the state or states are regulating that chemical, because EPA hasn't done anything yet with a chemical. They're just investigating it. But yet the states are prevented from doing anything that either restricts or prohibits the use of that chemical. So you have up to 3.5 years where there's no regulation. In other words, it's a form of preemption. And again, this is very unique to consumer protection laws, and it's something that industry fought for and ultimately was able to keep in the bill. The next type of preemption you're going to have for new state laws is where EPA has actually then taken that final agency action. They've completed the risk evaluation, and they've either decided that the chemical does not present an unreasonable risk, or if it does, then they've implemented the Section 6A restrictions. And so at that point, you kind of have permanent preemption. That is when it finally kicks in for good, and the states can't act any longer. Again, same rule for test rules and significant new use restrictions, same thing I mentioned before. If EPA has adopted one of those, even for new state laws, you're going to have preemption for those once EPA acts on that given chemical. But again, no preemption for new state laws for low priority chemicals, for Prop 68, or for any chemical that EPA hasn't addressed. EPA has to take some sort of action on a given chemical for a given use before preemption even comes into play. And then finally, conflict preemption could come into play with new state laws. It gets a little complicated, so I'll just leave it at that, but that's something you should always ask. Is conflict preemption still in play here, even with a new state law? So what about exceptions? There are 4 specific ones, aside from the Prop 65 one that I've already talked about. The first one is where a state or a local government has adopted a provision, a restriction or a prohibition pursuant to federal law, so that makes sense. You're doing it because the federal government has told you to. The second exception is where a state adopts reporting, monitoring, or information laws, provided they don't duplicate an existing EPA rule. And I'm going to come back to this in a second because there's a little twist to it. The third exception is just basically environmental laws, where states or local governments have adopted air, water, hazardous waste, or disposal laws. The exception basically says, look, even if those have the practical effect of restricting or prohibiting the use, sale of a chemical, it is not preempted unless it directly conflicts with something EPA has done. And then finally, states are allowed to adopt the federal standard. They can adopt the same standard that EPA has put out and then co-enforce it. So going back to that second bullet point, the reporting, monitoring, and information laws, I think for all of us who are involved in the kind of debates and negotiations, we always understood that reporting and monitoring in particular to mean where a state, for example, said, look, you got to produce all the safety studies that you have to us, or you have to report all of the adverse event information that you have to us, kind of like Section 8 of TSCA. And so that was the way we understood that. But right after the bill passed Congress, but before President Obama signed it into law, 4 Democrat senators, including Senator Boxer, came out with what they called additional views, and they put this into the legislative record. And what they argued is that that word information actually includes labeling, use instructions, warnings. And I'm not aware of anyone who's interpreted it that way, but that's a huge expansion of that exception. So what happens if EPA addresses a chemical, they find it's high priority, they find it presents an unreasonable risk, and they do a 6A rule, but they don't impose any labeling restrictions? Is that enough now to preempt any state action? Or is a state like California going to come back and say, no, we can still impose labeling restrictions because it's accepted. There's nothing duplicating what you've done, EPA. And so I think this is an area that if people push that additional views section regarding labeling, that this is going to be something that could be litigated in the future, so we need to keep our eyes open for that. So we also have another way states can kind of get around preemption, and that is the state waiver provisions. The original TSCA had something similar to this. These are a little different, and so there are 2 types. The first is discretionary, and under both of these, states would apply to EPA, and then EPA needs to make a finding that the waiver applies. And so the first one is discretionary, and that's where EPA has taken that final agency action on a chemical. So it's a high priority chemical. They've decided whether it poses an unreasonable risk or not. If it does pose an unreasonable risk, then they do the Section 6A restrictions. And so if a state wants to get around that, it's a pretty high bar. So they have to meet these conditions. They have to show that there's a compelling condition for this. So even though we're preempted, we think we have some compelling reasons to be able to override that. And no one knows what this means. It's not defined in the reform bill. There are some other consumer protection statutes that do have similar language, and they've been interpreted various ways. And I won't get into those different ways, but that is another area that could be litigated in the future if states start trying to invoke this state waiver provision. You have to show there's no undue burden on interstate commerce, it doesn't cause violation of federal law, but you also have to show that your state rule or local rule is based on best available science and the weight of the scientific evidence. So again, this is kind of a high bar. So this is not going to be easy for states to get. So I guess that, or at least I would argue that's the case. So that's good news for industry. The second type of waiver is the mandatory waiver. So if the state meets the various requirements, then EPA has to grant it. And that is where a state is trying to get around that preemption pause, where during the risk evaluation, the risk assessment, they would otherwise be preempted from acting, but they're telling the EPA, no, we got to move ahead and we need to take action. And so there are two ways for the states to avoid that preemption kind of pause. And the first is similar to the discretionary waiver. They have to show no undue burden, won't cause violation of federal law, and it's based on peer-reviewed science. And this is a little lower bar, I think. They don't have to. They just have to show that they're concerned about something based on peer-reviewed science. They don't have to justify it with the weight of the scientific evidence or best available science. So the bar is a little lower, and that makes sense because we're not dealing with a situation where a state is trying to regulate and get around permanent preemption. It's just that brief pause that they're trying to avoid. So the hurdle is a little lower for them to get around. But here's the important thing. Right at the end, right before the final bill came out, Barbara Boxer, or Senator Boxer, we think, came up with this additional way to get around the preemption pause. And that is if within the 18 months from when that high priority chemical, the prioritization process starts, so that's even before the scope of the risk evaluation is defined. So this is really early in the process. If within 18 months of that, the state either enacts a statute regarding that particular chemical, or it proposes and or finalizes a certain administrative rule or regulation, again, regarding that chemical, that they meet the mandatory requirements, and then they get around the preemption pause. So this is important because at least for states like California, Minnesota, Vermont, and other, New York, other states that have both the resources and the initiative to kind of take advantage of this exception or this waiver, this basically writes out of the statute the preemption pause. And so even though industry was able to keep that in there, that preemption pause, and get preemption earlier in the process, this kind of negates, at least for some states, that advantage to the industry. And so that's something to keep an eye open for, our eyes open for, and in particular, I think this applies to things like green chemistry statutes, like in California, where they're going to continually be, states are continually evaluating chemicals, and so if they can do that within 18 months, they can get around that preemption pause. The last thing I'll mention before a couple of concluding remarks is that there was a long debate, especially early in this process a couple of years ago, about what effect this reform bill would have on tort actions. This is, like Aaron Brockovich or the civil action with John Travolta, where plaintiffs sue companies for exposure to hazardous materials. And whether or not anything that could happen in the TSCA regulatory world, for example, a decision by EPA that something's not an unreasonable risk or is an unreasonable risk, could have any impact on those court actions. And so the plaintiff's bar, the plaintiff's lawyers, fought very hard and won, and got a very extensive, what we call savings clause, included in the reform bill, which basically says that tort actions are not preempted by anything EPA does and can affect those court actions. And so that was a big victory for them. And right at the end, again, in the additional views document, those 4 senators, including Senator Boxer, actually got in there and said that even conflict preemption does not apply in this instance. So just to give you an example, if a judge enters a final judgment saying that the defendant should have used the word danger on their labels, kind of a failure to warn type tort case, but yet EPA was saying to the defendant, manufacturer, you only need to use the word warning, that direct conflict will not mean that EPA wins out. That's what they are arguing. And of course that makes no sense. And so I think, again, that is going to be another area of litigation where plaintiffs' lawyers are going to point to that additional views section that was entered into the legislative record as proof that conflict preemption should not apply, and of course the defendants will argue otherwise. So keep that in mind. I think the upshot of all of this for business is that you should not assume you're going to see any meaningful preemption anytime soon. And the reason is that as you may have gathered from Tom's presentation, that the process of evaluating and making final agency decisions on these chemicals is going to take a very long time. The schedule, only envisions, 10 in the beginning and then 20 in 3 years. And so you can, and those chemicals are going to be chemicals that everyone knows about, that have already kind of been deselected through market pressures. And so by the time we get to chemicals that kind of are further down the list, and preemption could kick in at some point, that's going to take a while. So the idea that industry is going to be able to avoid patchwork regulation anytime in the near future is probably wishful thinking. But that is the way it played out. Those are the compromises industry made in negotiating this bill, and that's what we're going to have to live with going forward. So that concludes my comments and presentation on preemption, and I hope it was helpful. And if you have any questions, please let us know.
Thanks, Eric. That was great. I'm now going to hand it over to Zephin.
Thank you, Jessica. In today's ever-growing regulatory landscape, maintaining compliance can sometimes seem overwhelming. In order to overcome the difficulties in tracking substances of concern for products, new technologies will need to be implemented. This issue becomes even more clear when considering that companies will typically have to deal with many constantly evolving regulations. For example, California Prop 65 or ROS and REACH in the EU. One way to stay compliant with so many different types of requirements is to proactively identify product issues through supply chain transparency. This can be done through a method of gathering information on your product components through your supply chain in the form of full material disclosures, or FMDs. These FMDs are lists of chemical makeups for the product parts that can be used to be checked for regulations in the government, internal standards, or other NGOs. As you have already heard, fulfilling the TSCA regulation requirements can seem daunting. The first step towards compliance is to screen your products for restricted substances and substances that are listed in significant new use rules, SNURs. As TSCA compliance evolves in the coming years, we'll also need to check against chemicals that are listed as high priority, restricted, or even banned. Here at Source Intelligence, we help you maintain this through supply chain transparency, specifically by collecting FMDs, and then being able to take those chemical lists and check them against regulatory substance lists, whether it be through TSCA or applied to ROS, REACH, California Prop 65, other regulations, or even internal standards. We're here to make sure that you stay compliant and successful.
All right, thanks, Stefan. So during the talks, we went through some of the questions that have been coming, and this first one is for you, Stefan. It's a bit long, so here's the abbreviated version. When I request compliance documentation from my suppliers, I mostly receive certificates. So what's the value of a full material declaration?
Thank you, Jessica. Good question. The more information that a company is able to collect about the supply chain, the more control they'll have in addressing the needs of their current regulations. Even in a situation when the company only has partial FMD information about a supply chain, they'll be in a better position to make proactive decisions. In addition, when a company relies on certificates from the supply chain, there is often an issue with managing an ever-growing document library for each regulation that they must comply with. For most global companies, this proves to be an overwhelming task. Certificates are also limited to the substance or regulation for which they have been prepared. For constantly evolving regulations, like TSCA, a full material disclosure will allow you to know all of the materials used to make a product down to the substance level, and that, of course, isn't dependent on the regulation you're looking at. Therefore, you can use a single piece of information to get information which can be compared against any restricted substance list, whether generated by a government body or private company.
Great, thanks, Stefan. So we have some time for a few more questions, and it looks like the next few will be for Tom. So Tom, the first question is, what should my company pay attention to first when I'm thinking about TSCA reform? So what areas will be the most immediately affected?
Yeah, I think that's a good question. I think a number of things will happen, say, in the first 12 months or so. As I mentioned under Section 12C, EPA is going to issue a rule that's going to include certain types of mercury compounds, so that's a short-term action if you are interested in exporting mercury of any kind. Some of the Section 6 rules will be done very quickly, and these are the rules where EPA is going to lay out its risk evaluation and risk assessment procedures. Those rulemakings, I think, will be happening in the short term. What else? As I mentioned, I think this inventory reset rule, where companies are going to have to notify EPA of all the chemicals that they manufactured or imported and possibly processed in the previous 10 years, that's going to happen in the short term. And you can think of that as kind of a CDR on steroids, right? As you probably know, CDR has generally a 25,000 pound per year per site threshold and excludes most polymers. And we do not think that will be the case for this reset rule. So it's going to cover many more years than CDR. It's going to cover 10 rather than 4. It's not going to exclude polymers, probably, and it's not going to have a volume threshold. So I think that's going to be a challenge for companies, not to mention the fact that CBI will have to be substantiated when those reports are submitted.
Okay, great, thank you. So another question is, what are the penalties or consequences for me if I'm using a restricted chemical under the new TSCA? And what if that chemical wasn't previously restricted?
That's another good question. As I mentioned in my presentation, Section 15 of TSCA, the penalty provisions in the Prohibited Acts have not been modified. So basically, what has increased, of course, were the penalties, as I mentioned, most notably on the criminal side of things. But basically, the penalty for, improperly using a SNUR substance, or violating a test rule, or violating a Section 6A rule, those penalties have not changed. And to become regulated under new TSCA, generally speaking, EPA has to issue an order or a rule or take some formal agency and final action. So companies should have notice that a chemical of interest is going to be regulated, and that should provide ample time to comply with the regulation. But if it does not, then the penalties are just the same, essentially, as they were before, or the structure at least is the same before TSCA was amended by 2576.
Thank you, Tom. We have one more question that we're going to answer today. What happens to the pre-manufacturing notices that were submitted before the law was passed?
Another excellent question. EPA has taken the position that basically 2576, when it was enacted on June 22nd, effectively restarted the 90-day review period for PMNs that were submitted before that date. So in our opinion, there's no clear legal basis for doing that, but in any event, that's EPA's position. And that means if you had a PMN that was near the end of the review process, it goes back to basically day 0 as of the 22nd, and you've got to wait the full 90 days. The good news is, as we pointed out, we now have this green light provision where under Section 5G, if EPA basically approves a PMN substance, you don't have to wait till the end of the review period. So I would urge companies to urge EPA to try to act as quickly as they can. And if the PMN is essentially approved by EPA under subparagraph C, then under 5G, you should be able to commence manufacture or import before the 90 days expires. I think it's also important to note that our understanding is that restart, if you will, only applies to PMNs and does not apply to low volume exemptions or what we call low REX exemptions that only have 30-day review periods.
Great. Thanks so much, Tom. It was really a pleasure to have both you and Eric on the webinar today. Thank you so much for speaking and for sharing your expertise. And once again to everyone, we will be following up shortly with the presentation deck as well as the recording of the webinar. We hope that this webinar has been informative and useful for you, and that it will help your company develop proactive compliance programs that recognize the importance of efficient data collection and management. Thank you everyone for joining us today. We look forward to next time. Have a great day.